Hello and a warm welcome to Well This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notification for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and let's begin with Supreme Court this week. This week, the Supreme Court reserved judgment in the matter pertaining to the political turmoil in Maharashtra as a rift within the Shiv Sena party between Uddhav Thackeray and Eknath Shinde group led to the change in the government in July 2022. The court has now reserved the judgment in a batch of petitions filed by both sides covering a wide range of issues relating to defection law and other legislative procedures. The first petition was filed by Eknath Shinde faction in June 2022, challenging the notices issued by the then Deputy Speaker against the rebels under the 10th schedule of the Constitution over alleged defection. Later, the Uddhav Thackeray faction filed petitions in the Supreme Court challenging the decisions of the Maharashtra governor to call for a trust vote and following the swearing in of Eknath Shinde as the Chief Minister of the government with the backing of BJP, the election of a new speaker, etc. The matter was first catered by a 3-judge bench which later transferred it to the Constitution bench in August 2022. A 5-judge bench of Chief Justice D.Y. Chandrachud, Justice M.R. Shah, Justice Krishna Murari, Justice Hema Kohli and Justice P.S. Narasimha started hearing the matter on February 14 this year. The preliminary issue as was raised by Uddhav Thackeray's side was that the matter should be referred to the larger bench to reconsider the dictum laid down in the Nabam Rabia and Bamang Felix versus Deputy Speaker and others judgment that the Speaker cannot issue disqualification notices when a notice seeking their removal is pending. The Apex Court has also reserved its order in another important matter which deals with the issue as to whether its 2017 verdict laying down guidelines for itself and high courts for designating lawyers as senior advocates require any tweaking. Additional Solicitor General appearing for the centre told a bench headed by Justice S.K. Kaul that the 2017 verdict needs reconsideration. Senior Advocate Indra Jaising, on the other hand, whose petition the verdict was delivered, told the bench that the government has no role in designating lawyers as senior advocates as it has not filed any petition seeking a review of the verdict. The top court was earlier told that the October 2017 verdict had noted that the guidelines enumerated in it may not be exhaustive of all the matter and may require reconsideration by suitable additions and deletions in the light of experience to be gained over a period of time. In May last year, the top court had modified one of its earlier directions and said that the lawyers be allocated 1 mark each for a year of practice from 10 to 20 years while being considered for designation as senior advocates. Earlier, the Apex Court had agreed to consider plea seeking a declaration of the process adopted by some high courts to confer the senior designation to advocates through the process of secret voting the full court as arbitrary and discriminatory. In 2017, the top court laid down guidelines for itself and the high courts to govern the exercise of designating lawyers as seniors. One of the guidelines provided that advocates with practice between 10 to 20 years will be awarded 10 marks each for the experience as lawyers while being considered for the designation as seniors. The Supreme Court has held that wills cannot be provided only based on their age. Wills must be proven in accordance with the Section 63C of the Successions Act 1925 and 68 of the Evidence Act 1872, and there is no presumption under Section 90 about the regulatory of document older than 30 years. Further, there may be situation when wills which otherwise may have satisfied the requirement of being attested as provided by the law cannot be provided in terms of the said two provisions, for being the reason that the attesting witnesses are not available or in one of the witness denies having attested the will. Section 69 and 71 of the Evidence Act 1872 then comes to the aid of the propounder. It has been opined that Section 69 of the Evidence Act 1872 is applicable when attesting witnesses may have died or cannot be found. The Supreme Court has decided to consider the question as to whether a High Court could refuse to entertain an application for anticipatory bail under Section 438 of the Code of Civil Criminal Procedure on the ground that the applicant did not approach a sessions court first. A division bench of Justice Manoj Mishra and Justice Aravind Kumar, while issuing notice in the appeal, was of the view that decisions on the issue would have wide ramifications. The present legal opinion on the issue spreads over a range, with Allahabad High Court ruling that approaching High Court first without exhausting the remedy before Sessions Court under special circumstances is permissible, while Jammu and Kashmir and Ladakh High Court ruling that anticipatory bail applications should not be entertained by the High Courts unless the person apprehending the arrest has approached the Sessions Courts first, except in exceptional circumstances. The top court, hearing a batch of petitions seeking legal validation of same-sex marriage, has sent the matter to a 5-judge constitution bench. The hearing of the case will commence from April 18th. On November 25 last year, the Supreme Court saw the centre's response on two separate petitions moved by two gay couples seeking enforcement of their rights to marry and a direction to the authorities concerned to register their marriage under the Special Marriage Act. The petitions, on which the top court issued the notice, sought a direction that the right to marry a person of one's choice be extended to LGBTQ persons as part of their fundamental rights. One of the petitions sought an interpretation of the Special Marriage Act 1954 in a gender-neutral manner, where a person is not discriminated against due to his sexual orientation. The centre, in its affidavit filed, has strongly opposed the same-sex marriage, stating that the concept of an Indian family involves a biological man and a woman, and it won't be possible for the courts to change the entire legislative policy of the country that is deeply embedded in religious and societal norms. Next, we have Delhi High Court. The Delhi High Court has opined that the issue related as to whether the dispute arose from the MOU or the letter of intent can be looked into by the arbitrator, as according to the Section 16 of the Arbitration and Conciliation Act has held that arbitrator can decide his jurisdiction. Further, it was ruled that if the Memorandum of Understanding and Letter of Intent are found to be independent contracts, then also the arbitrator clause in MOU would be given effect. It was observed that if the contention of the respondent that the dispute relates to the letter of intent which had no arbitration clause was not substantiated, then the dispute would necessarily have to be decided via arbitration. Noting that nepotism doesn't fall under the definition of corruption, the Delhi High Court stayed the lower court proceedings against Delhi Commission for Women Chairperson Swati Maliwal till July 26 over alleged abuse of official position by illegally appointing various acquaintances, including AAP workers, in women's right body. A single judge bench of Justice Anup Jairam Bhambani said that prima facie the essential ingredient of an offence under Section 13(1)(d)(2) of the Prevention of Corruption Act, namely obtaining of any valuable thing or pecuniary advantage, was missing from the charge sheet. Appearing for Maliwal, Senior Advocate Rebecca John submitted that there was no allegation in the charge sheet about Maliwal receiving any advantage in the exchange of the appointments under the scanner. Jones stated that merely because Maliwal had worked with some appointees previously, it didn't mean that they were close to each other, adding that only competent people with relevant experience were appointed on a short-term basis. She submitted that the DCW was an autonomous body created by a statute and its appointment were made without the approval of the Delhi government. She added that even the audit and annual reports of the commission were placed before the legislative body for approval. The Delhi High Court has opined that Order 39 Rule 10 along with Order 15A of the Code of Civil Procedure is an interim measure that safeguards the interest of the owner. Noting that order as an interim measure has to be passed carefully and has to be given a broad interpretation so that the party claiming ownership is safeguarded, the court stated that solely because the trial is about to get concluded, the plaintiff cannot be deprived of their fair protection of his interest. It was held that the broad scope of Order 15A of the CPC, the trial court should not have restricted the decision to direct payment only to the admitted amount of rent. Now let's have an overview of other high courts. The Madras High Court has reiterated that accused is not entitled to claim as a matter of right the translated version of copies furnished under Section 207 CRPC in the mother tongue. Citing various judgments passed by the Supreme Court and the High Courts, the single-judge bench stated that if accused belonging to various states speaking various languages tried in a particular case, it is not possible to furnish copy of the documents relied on by the prosecution in their respective mother tongue. The Bombay High Court has observed that when there are doubts as to the existence of a concluded contract and there is a delay in instituting the suit, onus is on the plaintiff to demonstrate that the parties were ad idem qua their obligations concluded contract. Act of taking out demand draft or putting amount of text deducted at source in the account of somebody's account, specifically when there was a specific denial by an explanation by the defendant, then there is no such contract between the parties. There is no case made out for the grant of injunction, it added. The Allahabad High Court has observed that it was not open to the applicant after participating in the selection process to question the result on being declared unsuccessful. The court observed that since the advertisement does not provide for any language for CRT, the contention of the learned counsel for the petitioner that there is a violation of the terms and condition of the advertisement is misconceived and not tenable. It remarked that if the syllabus was in English language, it can safely be inferred that the question paper would be in English, and if the petitioners did not raise any objection at that stage, they cannot say now that the question paper should have been in Hindi also. Also, the Allahabad High Court observed that the illegal extraction of mines and minerals would fall under the category of immovable property. The court thus refused to quash proceedings arising out of case under Section 3(1) of the UP Gangsters Act 1986 and remarked that illegal extraction of mines and minerals would fall under the category of immovable property, and therefore any illegal activity in respect of illegal mining would definitely fall under the definition of gang. As soon as minerals are moved from one place to another, it would also fall under the offence of theft, the court said. Noting that filing GST returns isn't reasonable ground to reject license application for a business that's yet to commence, the Odisha High Court in a writ petition against non-granting of license for an IMFL restaurant on Owen Shop specifically made it clear that a business that is yet to commence cannot be expected to have filed GST returns and license applications should not be rejected on this basis. It was held that it is unrealistic to expect the GST return would be filed without actually commencing the business, and the same cannot be a ground for rejecting the Owen Shop license application for the petitioner. The Karnataka High Court has enunciated that the claimant was intoxicated or smelled of alcohol cannot be an excuse for offending driver for causing the road traffic accident and inflicting injuries to the victim. The single judge bench of Justice Dr. H.B. Prabhakar/3 asserted that such factors do not do away with the victim status of the claimant and relief cannot be denied. The tribunal had denied the claim on the ground that the claimant was intoxicated with alcohol at the time of the accident and was standing near the footpath but leaving the footpath on the edge of the road. It was thus held against this backdrop that there was no negligence on part of the driver of the bus. Moving on to miscellaneous news. In a major development, the Bar Council of India has allowed the entry of foreign lawyers and law firms to practice foreign law in India on a reciprocity basis, as it notified Bar Council of India rules for registration and regulation of foreign lawyers and foreign law firms in India 2022. The rules are framed to enable international lawyers and arbitration practitioners to practice in India. The bar has stated that the legal profession in India has to rise to the occasion to meet the global change in the legal arena caused by the migration of people from one country to another on such a large scale that had never witnessed in earlier days. Remarking that the world is becoming a global village, the rule states that the international trade and commerce is advancing at a greater pace and demand for an open, responsive and receptive legal profession dispensation mechanism in India from clients and public who operates in international and across country business is becoming very severe day by day. The Chief Justice of India, D.Y. Chandrachud, in strong words has condemned any kind of sexual harassment and inappropriate behavior towards women. While speaking at an event organized by the Gender Sensitization and Internal Complaints Committee of the Supreme Court for a belated celebration of the International Women's Day, the CJI disapproved of any kind of indecorous language and targeting women such as inappropriate jokes, comments, etc. He also revealed some strong steps that the judiciary plans to take in order to ensure zero tolerance. He announced two important plans. First, the launch of a glossary of inappropriate gender terms used in legal discourse, and second, the creation of a large space for women lawyers in Supreme Court's annex building, which is about to be renovated. A writ petition has been filed before the Supreme Court for a declaration that the designation of advocates as senior advocates under Section 16 and 23(5) of the Advocates Act 1961, as well as under Rule 2 of Chapter 4 of the Supreme Court Rules 2013, creating a special class of advocates with special rights, privileges and status not available to ordinary advocates, is unconstitutional. It is argued that the designation is violative of the mandate of the equality under Article 14 and the right to practice any profession under Article 19, as well as the right to life under Article 21. The Delhi State Consumer Dispute Redressal Commission has held Germany's Lufthansa Airlines guilty of negligence in providing service after a passenger lost 7 bags while travelling from Frankfurt to London. The Commission thus upheld the findings of the District Forum to compensate for the loss and mental harassment caused due to the mishandling of baggage of the passenger by Lufthansa Airlines. The Bar Council of India has agreed to look into the examine representation demanding that the Right of Children to Free and Compulsory Education Act 2019 RTE Act be made a compulsory subject for LLB in all law schools across the country. The court accordingly disposed of a PIL filed by a social jurist in which it was contended that even though the RTE Act came into force a long time back, but hardly any student, lawyer or even judge is aware of the provisions. The Bar Council of Kerala has challenged the Kerala High Court interim order directing it to enroll law students who petition before the court with statutorily prescribed nominal fee. The court had granted relief to 10 law students who challenged the high enrollment fees charged by the State Bar Council and directed it to accept their applications as against a fee of Rs 750 instead of Rs 15,900 fixed by it for time being. The BCK, in its appeal against the single judge order before the division bench, has stated that there is no statutory bar imposed on counsel from levying the requisite charges to satisfy the condition of enrollment from the candidates. It has been argued that the part of the council that the judgment has been passed relying on Koshi T versus Bar Council of Kerala, a 2017 Kerala High Court judgment ruling that the Bar Council cannot charge a higher fees and should restrict itself to the norms of Advocates Act but without analyzing its context. In an effort that is going to empower citizens, a consumer court in Vadodara has ruled that the hospitalization isn't mandatory to claim medical insurance. Insurance company insists on hospitalization for at least 24 hours to consumer to claim medical insurance benefits. This is other than the medical services that are covered day care scheme which need no hospitalization. In an order that is going to empower citizens, a consumer court in Vadodara has ruled that hospitalization is mandatory to claim medical insurance. In the end, we have international news. A US court has ruled that gig economy giants including Uber and Lyft can continue treating their workers as independent contractors in the state of California. The California Appeals Court found that a labor measure known as Proposition 22 was largely constitutional. Labor groups and some workers had opposed the measure, saying it robbed them of rights like sick leave. Apple Inc., Google LLC, Cisco Systems Inc. and others can sue the US Patent and Trademark Office to challenge a rule that reduced the number of patent validity proceedings at a US PTO tribunal, a US appeals court ruled. The court reserved a California federal court's decision to dismiss the company's lawsuit and said that the agency may have failed to go through a required public and comment rulemaking process. A Romanian court has rejected the latest application for bail filed by Andrew Tate. The controversial British social media influencer and his brother Tristan has been detained since December. They are being investigated on charges of rape, people trafficking and forming an organized crime group. Both have denied wrongdoings. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.